Good afternoon, ladies and gentlemen. C'est un grand plaisir de vous accueillir tous.
It's a great pleasure to welcome you all today.
Our study of Bill C-46, an act to amend the criminal code, offenses related to conveyances, and to make consequential amendments to other acts. It's one of the most important bills, I think, that's yet come before this committee in this session. And I look forward to hearing from the first of what looks to be a large number of witnesses. We're joined today by the Minister of Justice and Attorney General of Canada, the Honourable Jody Wilson-Raybould. Welcome, Minister.
Thank you, Mr. Chair.
And she is joined by three individuals from the Department of Justice. We have our very frequent visitor, Mr. Bill Pentney, who is the Deputy Minister of Justice and Deputy Attorney General of Canada. Welcome back, Mr. Pentney.
Thank you.
Also with Carole Morency, who is the Director General and Senior General Counsel of the Criminal Law Policy Section. Welcome, Madame Morency. And Greg Yost, who is the Counsel Criminal Law Policy Section. Welcome, Mr. Yost. And now, Minister, I am going to turn the floor over to you for your opening statement. And again, pleasure to have you here.
Well, thank you, Mr. Chair, and certainly thank you to all the members of this committee. I am always pleased to come back before all of you, and I appreciate the comments from the Chair about this being one of the most important pieces or bill to be before the committee, and I very much look forward to hearing feedback. So I'm pleased to be here to speak to Bill C-46, an act to amend the criminal code, offences relating to conveyances, and to make consequential amendments to other acts. The bill would strengthen the existing criminal law with respect to drug-impaired driving and would result in a simplified, modernized, and coherent legislative framework addressing all transportation offences, including impaired driving. The ultimate goal of this bill is to reduce deaths and injuries caused by impaired drivers. Drinking and driving continues to cause an untold devastation on our roads and highways, despite years of public education on the dangers of such conduct. No one is immune to its tragic impact. This was evident during the second reading debate when many members of Parliament related their personal stories of being impacted by an impaired driver. Some have lost family members of their own. Others described the impact that impaired driving has had on some of their constituents and communities. I would like to point out that since the introduction of this bill, questions around its constitutionality have been raised, particularly with respect to whether some of the key proposals will withstand charter scrutiny. I would like to assure the committee that I take my role under Section 4.1 of the Department of Justice Act very seriously. I am confident that the proposed reforms are appropriately tailored to the important objectives we are pursuing and will survive any constitutional challenge that may be brought. It has been my practice as Minister of Justice to table a charter statement. I did so with respect to Bill C-46, which outlines some of the key considerations that informed my review of the bill to ensure its consistency with the charter. The statement identifies how the bill potentially engages charter-protected rights and freedoms, and also identifies the rationale for justifying any limits that the bill may impose. My hope is that this information will be of assistance to all members as you study and continue to debate this important bill. I would like to now spend a few moments outlining some of the key proposals in the bill. As I mentioned, the bill proposes to strengthen the existing criminal law approach to drug-impaired driving. It would do this by enacting 3 new driving offences of being over a legal drug limit. The legal limits are not contained in the bill, but would be set by regulation. This approach would permit Cabinet to add drugs or amend legal limits quickly and efficiently in response to the evolving science. Although legal limits would be established for several impairing drugs, such as cocaine and methamphetamines, I propose only to outline the levels relating to THC, the primary impairing component of cannabis. The bill establishes a low-level, fine-only drug offense for THC. This represents a precautionary approach. This offense would prohibit having between 2 and 5 nanograms of THC per milliliter of blood within 2 hours of driving. This offense would be punishable by a maximum fine of $1,000 and a discretionary driving prohibition of up to 1 year. Additionally, Bill C-46 proposes a hybrid offense for a higher level of THC corresponding with higher risks of impairment or from impairment. This offense would prohibit having 5 nanograms or more of THC per milliliter of blood within 2 hours of driving. Finally, the second hybrid combination offense is proposed that would prohibit low levels of THC in combination with low levels of alcohol, recognizing that these two substances interact to significantly increase overall impairment. Both of the hybrid drug offenses would have escalating penalties that mirror the existing impaired driving penalties. A $1,000 fine for the first offense, 30 days imprisonment for a second offense, 120 days imprisonment for a third or subsequent offense, and mandatory prohibition orders. The bill also proposes to authorize the police to use roadside drug screeners to more effectively identify drivers who have been using drugs. These tools would be in addition to the existing roadside tests known as standard field sobriety tests. The ability to demand these tests has been in force since 2008. They are used by police to develop reasonable grounds to believe that a driver is impaired and proceed to further investigate. I am very pleased that last week, Minister Goodale announced that the drug screening device pilot project conducted between December 18th and 2016 and March 6th of 2017 by police officers in 7 jurisdictions across Canada was successful and received position reviews from police. Officers reported that the devices were easy to use at the roadside and that they were able to successfully use them in various weather, temperature, and lighting conditions. Giving law enforcement this tool to detect and deter drug-impaired driving will better protect communities. Bill C-46 also proposes significant reforms in the area of alcohol-impaired driving and other transportation-related provisions. It proposes to completely repeal these criminal code provisions and replace them with a simplified, modernized, and coherent legislative framework. One of the key proposals is to authorize mandatory alcohol screening. This proposal would allow a police officer in the lawful execution of their duty to demand a preliminary breath sample from any driver who is operating a motor vehicle. This provision was debated vigorously at second reading. I want to spend a moment explaining in some detail the reason this is proposed within the bill. Mandatory alcohol screening is common in other jurisdictions, including New Zealand, Australia, Ireland, Scotland, and much of Europe. It has been proven to significantly reduce traffic-related fatalities. In fact, in Ireland, it was credited with reducing the number of deaths on Irish roads by approximately 40% in the first 4 years after it was enacted. The Supreme Court of Canada has upheld the power of police officers to stop vehicles at any time to ensure that drivers are complying with the rules of the road. They can do this to ensure that drivers are licensed and insured, that the vehicle is mechanically fit, and to check for sobriety. The proposal in this bill would require a driver who is already subject to a lawful traffic stop to provide a breath sample, similar to the way they are now required to produce their license and registration. It is simply information about whether a driver is complying with one of the conditions imposed in the highly regulated context of driving. Some have expressed concern relating to the perceived risk that this provision could lead to an increase in racial profiling. While the issue of racial profiling is a serious concern to our government, mandatory alcohol screening will not have an impact on this practice. Mandatory alcohol screening would not alter the responsibility that law enforcement has towards training and oversight to ensure fair, equal, and appropriate application of the law. Finally, mandatory alcohol screening was unanimously recommended in 2009 by the members of this very committee, following a comprehensive study of the issue of impaired driving. I thank that committee for their hard work on this important issue, and I'm pleased to have been able to include that recommendation in this bill. As Minister of Justice and the Attorney General of Canada, I feel it is my obligation to take any and all reasonable measures within my authority to reduce the incidence of impaired driving with the ultimate goal of reducing road accidents. I am confident that the mandatory alcohol screening will be effective at reducing deaths and injuries on our roads and highways. I'm also confident that mandatory alcohol screening is constitutional. Constitutional compliance is about striking the appropriate balance. Mandatory alcohol screening is minimally intrusive, but the benefits in lives saved will be immeasurable. Simply put, mandatory alcohol screening will change the mindset of drivers, who will no longer be able to convince themselves that they can evade police detection of their alcohol consumption if stopped. Mr. Chair, the bill contains many other proposals that I do not have time to go into in great detail, but just for summary's sake, some of these elements include removing or limiting defences which encourage risk-taking behaviour, including the bolus or drinking and dashing defence, clarifying that the Crown is only required to disclose scientifically relevant information, simplifying the proof of alcohol or blood alcohol concentration, and increasing some minimum fines and some maximum penalties. I would like to draw the committee's attention to the legislative backgrounder on Bill C-45 that I tabled on May the 11th, which contains more detail regarding all of these proposed changes. It is my hope that this document will help guide your study by explaining in more detail the intent of the proposed changes. In conclusion, the ultimate goal of Bill C-46 is to save lives, reduce injuries, and ensure the safety of Canadians on our roads and highways. If passed, this bill would give Canada one of the toughest impaired driving regimes in the world. Protecting the public is a responsibility I take seriously, I know this committee takes seriously, and I'm very proud of the proposals set out in Bill C-46. Thank you for your attention, and I look forward to comments and questions, Mr. Chair.
Thank you very much for your statement, Minister Wilson-Raybould, and we're going to turn to questions from members of the committee, and we're going to start with Mr. Nicholson.
Well, thank you very much, and I'd like to welcome the Minister and all those members of the Department of Justice, and thank you for your appearance here today. There's quite a bit in this piece of legislation. I just wonder if you could just explain just again for me and the committee with respect to the mandatory testing. I mean, the law is now that, and as you pointed out correctly, that the courts have upheld the right of police officers to stop people, to check them for their insurance or to make sure their license is up to date. At that time, if they believe that the person was impaired, or they believe after they've stopped an individual, they are entitled to demand a breath test. Now, in your description of how this new regime would take place, would it be the same regime that they're stopping the individuals on a regular basis to check their insurance or their license, or would the sole purpose of stopping these people would be to test for impaired driving? You seem to say both of them. If they've got a lawful reason to stop the person, which has been decided, you can check on things like your insurance and licenses. Is the next step they can then or will have the mandatory testing, or are you suggesting, is this bill saying you can go by the roadside and just start pulling people over, and it's strictly alcohol? It has nothing to do with licenses or insurance. Thank you.
Well, thank you for the question, and appreciate the enormity or the length of this particular bill. In terms of the mandatory roadside screening, as you quite rightly indicate, it does not provide law enforcement officers with any additional powers, but certainly to pull people over on the roadside in compliance with the current laws. In terms of how the mandatory alcohol screenings will be administered, certainly we have to continue to work with law enforcement to support law enforcement officers with the ability of having the screening devices available to them, the training and testing with respect to various jurisdictions in terms of law enforcement officers, how the screening will unfold, I suspect would be a combination of the situations that you speak to, whether it be the random roads or the random roadside stops, or whether they be the roadblocks that come out at Christmas time. I know in other jurisdictions, in having these conversations, have discussions and do research around where there are situations where there's an increase in terms of impaired drivers driving, whether that be in the early morning hours, whether that be around a specific location in a city or in a town. But again, this is...
I can see that. Do you envision that it's in combination with the stop for people to check their insurance and their license, or is that necessary under this? The deputy may have a comment on this.
Well, a driver, a police officer can pull somebody over lawfully to, as you quite rightly say, to check their driver's license, to check their registration, to check if they are impaired by alcohol. And in any of those stops, a police officer, if they have the screening device, can administer that screening device.
This bill is in conjunction with C-45, with respect to cannabis and the legalization. But this specific section just refers to alcohol. Is that because you don't believe that the technology is there in place to immediately check on whether the person is also drug impaired, because it just refers to alcohol?
In terms of the mandatory roadside screening?
This bill with the mandatory roadside testing refers to alcohol. It doesn't refer to drugs. And
quite right. This Bill C-46, the impaired driving in terms of drug impaired and alcohol impaired, is a companion piece to C-45, which is the Cannabis Act. In terms of the mandatory roadside screening, it only applies to alcohol. We are ensuring that we continue to work with the best scientists and experts in this area who are helping and providing us advice in terms of the detection of drug impaired driving. And we've benefited greatly from the Drug and Driving Committee that have been working on the development of tools. And as I said in my comments, the science will continue to evolve, but as with other jurisdictions throughout the world that have followed similar processes in terms of approved devices for the oral fluid screening that is articulated in Part 1 in terms of drug impaired driving, we have benefited from the tests that Minister Goodale has undertaken, and are confident that we have an oral fluid screener that will, on the roadside, enable the first test in terms of drug impaired driving if there is a reasonable basis for a police officer to think that somebody has been influenced or impaired by drugs, to be able to administer the test, which would register a pass or a fail, or a positive or a negative.
Let me ask about the defense on the bolus drinking. Do you anticipate that there may be some challenges, some difficulties with that? I've seen cases over the years that an individual may or may not have been drinking, but after, for instance, say an accident, they have consumed some alcohol ostensibly to calm themselves after the accident. I suppose this would come within the definition here, and whether the person drank or not. Do you see problems in terms of proving, because it's what the condition of the individual is when the accident takes place, or when they're pulled over? That's the key moment, the amount of alcohol in there, not the amount of alcohol they consume afterwards. Do you think that this could be part of the challenges that this particular section is going to face?
Well, I mean, I think that simplifying or repealing some of the defenses around bolus drinking or around the intervening drug offense will significantly speed up trials around impaired driving. Adding the 2-hour time frame or in terms of the offense does this. There is a defense in terms of the intervening consumption, that there is a defense to that. If there was no anticipation that a police officer would come to one's home, or an anticipation that there was a presumption that they would be under the influence of drugs, the 2-hour time limit put around the time of driving is to eliminate the possibility of those defenses moving forward.
Something like that. I mean, we got... when we were in government, got rid of the 2-beer defense for just the same reason here, so people aren't manipulating the situation here to allow themselves to get off, which is otherwise a very serious problem. Thank you. I think I probably run out of time.
You did, but very important questions.
Okay, thank you.
Thank you very much, Mr. Nicholson. Mr. Fraser.
Merci beaucoup, Monsieur le Président. Thank you very much, Minister, and ladies and gentlemen, for being with us today to answer our questions on this important bill, and I appreciate the work that has gone into this, Minister. You touched on some of the elements dealing with the Charter that you address in the Charter statement that was put out. I'd like to ask you about the difference between random breath screening at a roadside checkpoint, which you touched on, and just any sort of traffic stop. Peter Hogg, a leading Canadian constitutional expert, offered an opinion that that actually only refers to checkpoints, and he talks about that in that situation there would not be a stigma or humiliation or irrelevant considerations going into who it is that's being chosen to actually take a random sample, irrelevant considerations such as race. I'm wondering, and you touched on it briefly in your statement, I'm wondering if you can explain why it was decided that it would not be just the roadside checkpoints, but that it would be at any traffic stop that a random sample could be taken.
Well, I appreciate the question and certainly welcome the views and opinions of this committee and other experts that may or may not come before the committee. In terms of the decision around you said random breath screening, we're talking about mandatory breath screening. This was a decision that was made based on experiences and practices in other jurisdictions that has been very successful in reducing the number of impaired drivers on our roads and significantly reducing the deaths on the roads. And it provides another tool for law enforcement officers to be able to, whether it's at a roadblock that we see as an example at Christmas, or if there is a random stop, to have an additional tool to ensure that there can be an identification of whether the individual is impaired by alcohol. It also, and what we've learned from other jurisdictions, it acts as a significant deterrent for individuals that think that there is some opportunity for them to calculate how much alcohol that they can drink before getting behind the wheel of a car. It's will be, and as we've learned from other jurisdictions, see people that are not wanting to take chances in terms of drinking before they get behind the wheel of a car. And in terms of our view and that broad public policy reason why we put forward and have mandatory screening is to ensure that we do everything we can to keep our roads safe, and it's based on that public policy objective and the reasonableness in terms of a very regulated environment that we deem it entirely appropriate to achieve its objectives.
Do you think it will be important to follow how this is actually being implemented in real life when people are being stopped, to ensure that it is not impacting, for example, more greatly on racial minorities that could be stopped for irrelevant considerations? Do you think it's important that we follow statistics on this and make sure that proper training is in place as well to ensure that it is being effectively utilized?
Well, I would say again to your question, this this bill does not provide law enforcement officers with additional tools, but that they are lawfully able to pull drivers over on the roadside for the reasons that we've discussed, and those reasons, whether it be driver's license, questions around the impairment of an individual have been upheld by the courts. I think that ensuring that we arm law enforcement officers with all the necessary tools, the necessary training, ensuring, and this is a different issue, but a very important issue that we need to continue to address, looking at implicit bias and having training around that is something that I entirely support. I know that my colleagues in government support, and ensuring that we monitor however we can and collect data, I think, is an important thing that we should do with respect to any new piece of legislation that comes into place. And we'll continue to work with the provinces and the territories as we see the rollout of this important piece of legislation. And there's a need to have time for jurisdictions to understand the impact of Part 2 of this legislation, and so the coming into force has been delayed.
Very good. And I think it will be very important to work with provinces and territories and having a continuous dialogue to understand how this actually is affecting people on the roads. With regard to training and tools and working with the provinces, what do you think about additional resources made available for training and tools actually that the provinces are asking for to ensure that this law has the intended effect on the ground and that it can be properly implemented?
Well, I think it's an incredibly important question. It's a question that I know, in looking at members' submissions in terms of the House of Commons around this bill, is something that all parties on every side of the House deems important, and we do as well, in terms of ensuring that law enforcement officers have the appropriate training, ensuring also that we have a substantive, or continue to have and maintain our public communication and education around the dangers of impaired driving, whether it be by drugs or alcohol, is something that we're going to continue to do. I was pleased to have the $9.6 million in the budget to go towards this education and communication. But also, in working with my colleague, the Minister of Public Safety, we've had substantive discussions around the necessary realities that this bill is going to and tools provide to law enforcement officers in the provinces and territories, and that we have to ensure that we're able to provide them those tools, and that includes providing them with the necessary training, the necessary resources in order to do their job to achieve the ultimate objectives of this bill, which is to keep our roads and highways safe. And my deputy just has a
I'm sorry, just one very brief, which I would encourage you to speak to witnesses as they come forward, because the current law is imposing a series of resource constraints right now on police, crown attorneys, and the judiciary. And as Mr. Nicholson noted in his comments earlier, some of that's related to defenses which are being brought forward, archival history, scientifically irrelevant evidence which is being demanded, and so that the effort in this bill to streamline the procedures associated with what is either the highest or second highest volume case occupying provincial court time generally across the country right now, to the extent that streamlining those prosecutions to get to justice, fair justice, more quickly, more efficiently, and eliminating dangerous defenses which are being, or defenses based on dangerous behavior or other things which we think are scientifically irrelevant, has to be a saving to the system as well. So I just note that I think that's worth exploring as it goes forward.
Thank you very much. Mr. McGregor.
Thank you, Mr. Chair. Welcome back, Minister, and it's good to see your officials again. I want to concentrate my line of questioning specifically on Section 320.27 because you have made some comments about the mandatory versus random nature of this law. Now, when police exercise their considerable powers under the criminal code, they usually have to show a reasonable suspicion that an offense has occurred in order to administer those powers, either to detain someone or bring them in for further questioning. The way this section is written, yes, a police officer has to lawfully stop someone on the road, either through speeding or a broken taillight. But then the decision on whether to administer a breath sample is entirely up to the officer. And I want to know, I mean, the real danger is here is what whims will affect the police officer's decision to administer that breath sample. And how is the Department of Justice going to implement that training to ensure that we are not disproportionately affecting certain groups of society more than others? Because the way the law is written, there's no real follow-up allowed with the officer to ask them, what made you administer the test? It seems to be entirely discretionary on the part of the officer, whereas before they had to prove a reasonable suspicion. So I'm just wondering, how is the Department of Justice going to make sure that this training is instituted in a proper way and that officers are acting with the best intention for all of their actions?
Well, I thank you for the question. Similar question to questions that have been asked, and I think it's really important. And I think that we've had this conversation around racial profiling, and will this mandatory breath screening impact racial minorities more than others? And I will say that, again, mandatory roadside screening acts as a deterrent. Officers, as you quite rightly point out, and others, can continue to lawfully pull individuals over. And I have to go back to one, I have confidence in law enforcement officers and the necessity for law enforcement officers in various jurisdictions to continue to get the necessary training that's required, and that includes how we deal with marginalized communities, how we deal with implicit bias. What's the Department of Justice going to do in this regard in terms of ensuring the application that law enforcement officers apply the screening device in a fair way? I've continued to have discussions with my counterparts in the provinces and territories, the attorneys general. We've had discussions about this particular piece of legislation and the impact, whether that be around training, and that includes resources as well. My colleague, the Minister of Public Safety, has indeed had conversations with his counterparts. In fact, we have federal, provincial, and territorial meetings together on many occasions. So I am committed to ensuring that we continue to have these discussions with our counterparts, continue to ensure that we provide the necessary support so law enforcement officers in their jurisdictions have the ability to access this training, have the ability to ensure that they can continue to improve on their training, and recognize that we need to separate and apart from the training around what's required in terms of administering the screening, understanding that racial profiling is also a serious issue that law enforcement officers, all people, actors in the criminal justice system need to be very aware of. And that's inherently part of my commitment in terms of my mandate letter from the Prime Minister, to be mindful of the realities that marginalized individuals face in our country.
Okay. The next question I want to ask Minister is with regard to the per se limits of THC. And now I know these will be set by regulation, but your department has already identified some numbers. Now, C46 can't be seen in isolation. Of course, you introduced it on the same day that C45 was introduced. And I know you want to have this law in place before C45 becomes the law. But the changes to Canada's marijuana laws will be quite a revolutionary thing. And I agree with the approach, the overall goal that C45 has. But the thing is if we have cannabis that is legal in Canadian society, it needs to be accompanied with that sort of public awareness campaign, because I don't think a lot of people have that strong correlation between how much you can ingest or inhale and what constitutes impairment. And I'm just wondering what studies or evidence does your department have correlating these specific numbers to impairment, because whether you eat something, whether you smoke something, whether you're a habitual user or a first-time user, they can all have different effects on how much of the drug is in your body, but they also could be very different to what constitutes impairment. So how has your department examined that particular issue?
Well, from the outset, in terms of drug-impaired driving, as I said in my comments, we're taking a precautionary approach. The premise being that no level of drug impairment or no level of ingestion of drugs is appropriate if you're planning on getting behind the wheel of your car. And as you quite rightly point out, the science with respect to impairment by drugs is not as clear as it is with respect to impairment by alcohol, which is why, with respect to Bill C-46 and around the per se limits, we have been and continue to take expert advice from the best scientific evidence that the Drugs and Driving Committee presents to us, and they're part of the Canadian Society for Forensic Science. We're going to continue to empower and embrace recommendations that come from them as the science continues to evolve. In terms of the levels that have been set, we have taken advice from them as well as levels that have been set in other jurisdictions.
Thank you very much, Mr. McGregor. Ms. Khalid.
Thank you, Chair, and thank you, Minister, for coming in today. Minister, I think the committee has really expressed today the importance of equality when it comes to administering this type of justice. And in Toronto, we have an issue of carding, where between 2008 and 2013, 2.1 million cards containing information on law-abiding citizens were filled out by Toronto Police, and it involved 1 million people. The majority were African Canadian. So racial profiling is definitely an issue, and I hope that you will consider that in this legislation going forward. Can you please talk about the distinction between medical marijuana versus recreational in the regulations, with respect to whether there will be a distinction with the impaired driving?
Well, just in terms of your comments around racial profiling, I take the point incredibly seriously, and again, ensuring that law enforcement officers have the appropriate training and the implicit bias training, and recognize that if a lawful stop happens and there's the perception or an overt bias of a law enforcement officer to an individual, that individual can challenge that reality. In terms of medical marijuana and what would be a legal source of marijuana, we have not made a distinction in this bill with respect to whether you're impaired by medical marijuana or impaired by a legal source of cannabis in Bill C-46. Any impairment, whether that be by a medical source or a licensed distributor in a province or a territory of legal marijuana to an adult over the age of 18, it's not appropriate to use cannabis and get behind the wheel of a car. We haven't made any distinction between the two. The public purpose is to ensure that anybody that's impaired by drugs or alcohol does not drive their car.
If I could just add just one point, which is that it's equally illegal now to be behind the wheel driving impaired by alcohol as it is to be behind the wheel impaired by a prescription drug you're taking for medically necessary purposes completely legally and lawfully. We know that there's many drugs, over-the-counter drugs, that say if you take this, it could impair you. So, lawful or illegal, if the substance causes impairment, you shouldn't be driving.
Thank you. Minister, paragraph 8 of Bill C-46 preamble notes the importance for federal and provincial laws to work together to promote the safe operation of motor vehicles. To what extent do provincial and federal laws complement each other to promote the safe operation of motor vehicles, and also will provincial laws need to be changed once Bill C-46 comes into effect?
Well, in terms of C46, we have and will continue to work with the provinces and territories in terms of ensuring that the criminal code is applied in their jurisdictions. Certainly, the provinces have highway traffic acts and have instituted various measures to do their part within their jurisdiction to ensure their highways are safe. They have actually across in the majority of provinces have instituted a lower level of alcohol concentration to 50 as opposed to what is federally within the criminal code at 80. But we're going to continue to ensure that we work with the provinces and territories to provide them with the ability to adapt their current approaches. And provinces and territories have been quite innovative in terms of impaired driving, instituting administrative penalties, like in the province of British Columbia, for example, that have significantly reduced delays. Take a car away from a driver that's impaired, and various other means to prevent or deter people from driving. So.
Thank you. So, with respect to working with the provinces and territories, will there be a financial assistance component to it as well, in terms of helping provide training and equipment, etc., for the provinces and territories?
Well, again, it's an important question. We're putting in place a very strong regime around impaired driving and introducing new tools. And in my conversations with the Minister of Public Safety, and we've had conversations in addition to the money that's already been provided to provinces and territories that we need to ensure that we provide the necessary resources for law enforcement officers to, one, have access to tools and have the necessary training around the administration of those tools to ensure we achieve the objectives that's laid out in Bill C-46.
Thank you.
Thank you very much, Ms. Khalid. We'll now move to the second round of questions, and we're going to start with Mr. McKinnon.
Thank you, Chair. Thank you, Minister and officials, for being here. I was going to talk about per se limits, but Mr. McGregor did a fine job with that, and I appreciate your answers to him. So I'm going to do a bit of a change of pace here. It appears that a lot of the work done here in this bill is to substantially rewrite a major section of the criminal code, to clarify and to streamline things, as it were. It seems that in that process, a number of offenses have been eliminated, such as street racing, failure to keep watch of a person being towed, and so forth. So I wonder if you could speak to those matters and whether they're going to be reintroduced in some other fashion, or whether they're no longer relevant.
As I think any reasonable examination of the history of impaired driving laws would show that they have been around for a long time, they have been adjusted quite often, and at the end of that, like many carpenters working on renovations to a house, it may not be that the golden thread is as evident throughout. And so I would say that partly the effort here is to make sure that where there are duplicate offenses, where there are kind of needlessly specific offenses that are covered by more general provisions, that we should streamline and simplify that. I think the Law Reform Commission at one point had described parts of this law as virtually unintelligible, even to senior lawyers and crowns. That's not good for anyone. That's not good for ordinary Canadians. That's not good for those that want to help address this, or for those that are involved in the administration, the ordinary police officer or the judge or the lawyer. So the effort here is to ensure that the harms that are to be addressed are covered by appropriately descriptive provisions, but also to streamline and reduce where there's overlap, or in some cases, frankly, I think, needlessly specific offenses where the more general is already would be sufficient. So I think that's a fair summary of the effort to try to streamline and simplify this, and to make the law more effective and more easily applied. This is one of the most heavily litigated areas of criminal law, and we think that we can streamline and make the law equally effective without leaving a public harm that ought to be addressed outside of the law.
And I guess just to add on to the deputy's comments, and I understand there's a robust group of witnesses that are coming in, so we would benefit from your thoughts around if we've hit the mark, and experts that are fundamentally involved in prosecuting and defending impaired driving to contribute to the discussion.
Okay. So I guess what I'm understanding from this is that offenses such as street racing might be encompassed now in something more general like dangerous driving?
That's the broader offense, so dangerous driving would encompass that,
okay.
Yes.
And in this vein, there's also an offense that seems to be being repealed, which is offenses of flight causing bodily harm or death. That seems to be a very serious offense. I'm wondering if there is really an offense that encompasses that.
Yeah. In fact, the offense as written today is a person who, while fleeing from the police, drives dangerously, commits and injures someone or kills them, commits the offense. The only purpose of that specific offense was to raise the maximum penalty in the case of bodily harm from 10 to 14 years, in the case of death from 14 years to life. By making the dangerous offense, raising the maximums for the dangerous driving causing bodily harm and death, there's no need for those particular offenses. The actual flight from police, simpliciter, if I can call it, remains as an offense. So if somebody fleeing from the police drives dangerously and injures someone, they would face a charge of dangerous driving causing bodily harm, and they would face a separate charge of flight from police under the new provisions.
Okay, great, thank you. I want to go back now to the testing for per se limits. So there is an alcohol test committee that has for 50 years been doing testing relating to alcohol impairment. I'm wondering if there is going to be a similar committee for drug impairment. And I'm wondering if, in fact, if there are objectively determined standards for impairment that we can measure these drugs against. Or maybe these are questions to ask the experts later.
I mean, maybe I could just say that there is the Drug Impaired Driving Committee that we are continuing to hear from. They're experts, scientific experts, so we take advice from them. Maybe I can ask Greg to speak to the second part of your question.
Well, the Drugs and Driving Committee has been examining standards that are used in other countries, for example, in the United Kingdom, in order to validate the technology and authorize for use drug screening devices. They are developing standards, looking at those to see if they're applicable to Canada. That work is ongoing. We expect their report in time for us to be able to approve certain roadside screeners for use by police in Canadian conditions, which are somewhat different than the United Kingdom for weather and such like. But the work is ongoing. It is also, like the Alcohol Test Committee, a subcommittee of the Canadian Society of Forensic Science, so it's at arm's length from government.
Okay, great. Thank you.
Thank you very much, Mr. McKinnon. Mr. Cooper.
Thank you, Minister, and thank you to the officials for being here. It's a big bill. There's a number of good aspects to the bill. There are other areas that I have some concerns with. One of the areas that I do have concerns with and that I want to discuss and drill down a little more on is random breath testing. Right now, in terms of the standard of reasonable suspicion, that standard is one of reasonable suspicion, not that someone is impaired or a reasonable suspicion that they are over the 0.08 limit, but rather a reasonable suspicion that they have alcohol in their system. That's a pretty low standard, wouldn't you agree, Minister?
Well, in terms of the alcohol testing and in terms of the mandatory breath screening that we're proposing, it would enable an officer to do it as a matter of the practice within their responsibilities.
Right. Now, you had indicated that one of the reasons, perhaps the only reason, I don't know, why, as a matter of policy, the choice has been made to authorize random breath testing is based upon the alleged success that it has had in other jurisdictions? Is that the basis?
Well, we've inserted not random breath screening, but mandatory breath screening, and there's many reasons for why we've done that. Certainly, it's based on what we've learned from other jurisdictions in terms of preventing the number of accidents on the highways, significantly reducing the number of deaths. It certainly acts as a deterrent factor. And what we've also learned from evidence is that a significant number of drivers, whether it's at a roadblock that has been erected by police officers, up to 50% of drivers manage to drive through the roadblock and while they have been impaired by alcohol. And this is was also actually mandatory screening was also proposed in Private Members Bill 226, as you know, Mr. Cooper, and the public policy reason for the mandatory roadside screening is to ensure that we prevent deaths, and I think that is entirely reasonable in the circumstances.
Well, Madam Minister, one of the concerns that I have with some of the studies in other jurisdictions is that no jurisdiction is the same, and in addition to that, in many jurisdictions, mandatory breath testing or random breath testing, whatever you want to call it, was instituted as one of the first measures that was taken to crack down on impaired driving. In Canada, we have had selective breath testing, and we have seen a significant reduction in the number of people who are driving impaired and deaths as a result of impaired driving, although, of course, the carnage is still too high, and everyone agrees on that point. But I'm not aware of any study that actually directly assessed the impact of mandatory breath testing with selective breath testing. Are you aware of any studies?
Everybody's turning to me. There have been a lot of studies in Australia when this was introduced in the mid-'80s and to the early '90s. In many cases, as I understand it, they had already tried approved, what we would call an approved screening device test, and that wasn't having the results they wanted. However, I'm not an expert on the state of Australian law in the 1980s when they brought in RBT. I do believe that Ireland, which had such excellent results when they brought in mandatory alcohol testing, as they call it, already had the over 80 offense and already had the ability to check people at the side of the road. I know nothing about European laws when they brought it in because my knowledge of other languages.
Okay. Well, thank you, and certainly I would be very interested in any studies because, yeah.
Sorry, if I could add, I think when Bill C-226 was also being studied previously by the SECU committee, the issue was asked there as well, and it's probably, if you look at the successes in addressing impaired driving over the years, it's probably a combination of many things. Public education, huge. Yeah. Training for law enforcement, also important. New legal framework to provide new tools to detect and to better address the issue, also a combination on the mandatory alcohol screening or random breath testing, as it's called elsewhere. It's also probably related to a function of how many police you put at different points to do the random testing, or as proposed here, mandatory alcohol.
Well,
I'm sorry, I know we're prolonging this. Just one other point, which is that it's mandatory if the police ask. We hope that police use a whole variety of innovative techniques to ensure that the deterrence effect that we're seeking is achieved by the application of the law. And we're not saying that every police officer that stops every person for a broken taillight must ask, but we are saying that everyone who gets pulled over for whatever reason in whatever context should know that they might be asked, and if asked, they have a legal obligation to comply. We know with social media and otherwise the capacity of Canadians and others to defeat this needs to be, and we would expect it to be taken into account by the way in which the police administer this. So random, I shouldn't describe, a variety of techniques to try to make this effective is what we hope for in the application of the law.
Yeah. Well, certainly I would be very interested in any study because let's not underestimate the fact that this is a significant infringement on individual liberty when we're talking about taking a bodily sample with even the slightest hint of suspicion that someone is breaking the law. And I would also, I think it was Mr. Yost who brought up the point about the success that Ireland has had. Now, the system in Ireland differs from what is proposed in Bill C-46 in the sense that the mandatory breath testing can only take place at regulated check stops. I would be curious as to why that was not considered. It would seem to me that that would be something that a lot of people would be a little more comfortable with than a mandatory roadside testing system where a police officer can stop any vehicle anywhere under any circumstances, albeit for a lawful stop to check registration, insurance, etc. And before you comment on that, I would just note, Madam Minister, because you had mentioned and the point had been raised by others that right now police can stop a vehicle to check insurance, to check registration, to frankly check for sobriety by engaging in a conversation with an individual, and if they have a reasonable suspicion, they can take further steps. But I would just note that when we're talking about taking a mandatory, a breath sample, a bodily sample from an individual, we're talking about something that's much more significant. And to that point, I would just draw your attention to the Goodwin decision from the Supreme Court, wherein Madam Justice Karakatsanis stated that taking breath samples remain, quote, more intrusive than a demand for documents and clearly amounts to what Justice Laforet described as the use of a person's body without his consent to obtain information about him by which the state invades an area of personal privacy essential to the maintenance of his human dignity. I mean, that is a fairly significant statement from the Supreme Court.
If I may, there are huge practical differences between Ireland, a small country with a population of about 4.5–5 million, where it is, and Canada, a huge country. Large parts of our country have small detachments, and the resources required to run full check-stop programs are enormous. They're so enormous that even in large cities like Toronto, they're really reserved for a few seasons of the year. If it was required that it be at a check stop, it probably would not have much effect at all. The other thing is, in Australia, a review of the random breath testing program said that you've got to be unpredictable. You can't be in the same place all the time, the same resources, because people will drive around you. So it's essential that you be unpredictable, and that's what this would be.
I would just add and appreciate the thoughtful nature of your questions, and I know that you likely have read the charter statement that I was able to table with respect to this bill. It answers some of those questions in there, and I would encourage all members of this committee to read that, as well as the backgrounder that actually provides more information, as well as substantive background in terms of what the Drugs and Driving Committee has recommended in their executive summary. So there's information out there, but I appreciate the thoughtful comments. Thank you.
Thank you very much. Mr. Biddle.
Thank you so much. Thank you, Minister, for coming today to testify. I know you and your officials have talked about the mandatory alcohol screening in other jurisdictions, but I was wondering if you could expand on the benefits in a bit more detailed way rather than supportive, but just to explain in which jurisdictions have shown the success and the numbers that have backed that up.
Sure. We've worked very closely with MAD in this. There are there's a lot of information. According to MAD, there's more than 40 countries worldwide that have authorized mandatory alcohol screening. And as I said, these include Australia, New Zealand, Austria, Belgium, Denmark, Finland, France, Germany, Ireland, the Netherlands, and Sweden, to name a few. Mandatory alcohol screening came into force in Ireland in July of 2006. and it was credited by the roadside or the Road Safety Authority at reducing the number of people being killed on Irish roads by almost a quarter, 23%, in the 11 months following its introduction. And in 2005, the last full year in Ireland without mandatory alcohol screening, road fatalities were 398, and by 2009, fatalities on Irish roads had declined to 238, a reduction of 39.9% from 2005.
Thank you so much. I didn't practice in the area of criminal law, and we've heard a lot about the delays in the criminal justice system. I saw it in the civil side and heard from my family law colleagues that even delays within the criminal law system have the spillover. So the abused wife seeking, abused spouse seeking to divorce their spouse, or a small business owner looking to get back an unpaid debt, and these delays impact even beyond the criminal justice system and impact middle-class Canadians who depend on the justice system in times of need. As one of the most litigated matters before the court, can you explain how this bill will ease the delays of our justice system as a whole?
Well, I think it's a really good question, and the deputy touched on it, and you did as well, in terms of one of the most litigated areas that contribute towards delays. We believe that the efficiencies and the redrafting of the transportation provisions in this bill will significantly reduce or assist in the reduction of delays in and around eliminating defenses, clarifying the disclosure realities for prosecutors, and the proof of the blood alcohol concentration, to name a few. But court delays generally are something that we certainly need to combat, and in terms of impaired driving, we're seeking to eliminate some of those delays by virtue of this bill.
And if I could just add that I think, for example, the BC experience shows that a more effective law and a more effective deterrent, ultimately we shouldn't be having any prosecutions for drunk driving because somebody should be driving drunk. So that will be the ultimate reduction in delays. What British Columbia has shown with immediate roadside prohibitions and the deterrence effect associated with that is that you should be able to see a reduction in charges proceeding. So we would hope to see less impaired driving, more use by provinces of their tools to more immediately deal with first-time impaired drivers, and fewer cases going to court. So there's the two elements of streamlining, but also a deterrent effect. We should be looking for fewer cases going to court because fewer people are driving impaired.
So of these provisions, have you heard support from your provincial and territorial colleagues on these points?
I've had the opportunity to continue to engage with discussions with my counterparts, but certainly discussions have been ongoing at the officials level, and what we've put in here are reflective of those discussions.
Perhaps this is a bit of an unfair question to put you on the spot, Minister. Maybe your departmental staff have this statistic, but I'm just curious. What is the percentage of impaired driving cases that go to trial, if you have that statistic, or versus other charges, if that's available to you?
I don't know if Greg, we can certainly get you that, but what we do know is that the mandatory nature of the penalties associated means that more cases with MMPs go to trial. But we can certainly get you the percentage, as well as the percentage of cases having gone to trial result in a conviction.
Thank you. Very quickly, you talked about mandatory minimums, and we often, as a government, have discussed the constitutional issues with mandatory minimums, except for certain particular types of offences. Can you explain the importance of mandatory minimums and keeping mandatory minimums with impaired driving offences?
Well, thanks for the question, and I know that discussion around mandatory minimum penalties is going to be an ongoing discussion that we're having. In terms of mandatory minimum penalties and maintaining them with respect to impaired driving, there isn't a significant factual difference that one can be charged with in terms of impaired driving. Mandatory minimums have acted as a deterrent with respect to impaired driving, and in that we, unlike other mandatory minimum penalties that the Supreme Court of Canada has weighed in on, where there is a significant difference in terms of the factual circumstances that can lead to a conviction, mandatory minimums are in line constitutionally.
Thank you. Thank you, Minister.
Thank you very much, Mr. Biddle. We have two more questioners. So we next go to Mr. Falk and then Mr. McGregor. Are you pressed for time, Minister? Are you okay?
We were supposed to go to 4:30, but I'm happy to take one more question.
Thanks.
Thanks, Mr. Chairman.
And it's from you, Mr. Falk. Thank you, Minister. I appreciate it.
I'm sure the Minister was eagerly waiting for my question. I want to change direction just a little bit, Minister. Alcohol impairment is often fairly easy to detect on people. Drug impairment less visible and less easily detectable. And I'm thinking specifically of the transportation industry, the construction industry, where individuals who may decide once cannabis is legal to experiment recreationally with it, or even to become users recreationally. And at the moment, I know there's employers, whether they be in public transit or commercial goods carrier or construction industry, they do have methods of determining whether their employees are impaired from alcohol. But have you considered at all how employers will be able to work with individuals that may be drug impaired?
Well, I mean, I guess I would say, as a general comment, impairment in the workplace is something that I think from all accounts is seen as unacceptable. The regulation or the implications of an individual that's in a workplace that is impaired would be determinative of the employer and the jurisdiction that activity would fall within.
I understand that, but there are some employers that buy very affordable breathalyzers and require their employees to submit a breath sample when they're suspicious that there could be impairment. But I'm wondering, in a situation where they're suspicious of impairment due to the use of cannabis, whether there's an affordable means that would be available to them to make those determinations.
Well, I'm not sure I have an answer to your question, or that I can provide an answer to your question. I mean, we have sought, if we're talking about cannabis impairment, we are working to develop approved devices to enable us to ensure that we can provide accurate roadside fluid screening. These devices would be made available if it is the desire of employers or other jurisdictions to be able to, within the confines of the law and the charter, to administer and screen their employees. Then that's their prerogative. I wouldn't speak on behalf of an employer to engage with their employees.
And this is certainly under active discussion. For example, in respect of transportation, there are industries now where drug testing is already the norm. There's other countries that have experience. So other ministers, other departments, and other processes are certainly looking within federal jurisdiction and within provincial jurisdiction of ways in which employers who have a legitimate safety concern can decide whether they want to undertake testing and what would be the legal framework around that. That would be a combination of presumably federal regulation in respect of, for example, airline pilots or railway engineers, and provincial regulation in respect of certain construction or transportation trades, as you talked about.
Well, I think it's an important issue that also needs to be addressed, that there needs to be mechanisms that employers can use to help identify risks. I mean, that's the whole objection of this litigation or a piece of legislation to make sure that we can reduce the traffic fatalities, reduce the levels of impairment driving, and that should also apply to public transportation, and there should be ways that we can address that, because typically the police officers aren't involved in enforcing those unless there's an incident.
I mean, I guess I could end by saying this is a point at which we agree. And in order for us to do everything we can to reduce the risk and increase safety on our roads, to ensure that we do everything we can, that negative impacts of drug impairment or alcohol impairment do not impact the public, is something that the federal government is committed to, and I'm sure our counterparts in the provinces and territories, as well as employers, want to ensure that they have safe workplaces, safe roads, and safe spaces for individuals to be protected.
Minister, I think you're maybe misinterpreting a little bit what I'm saying. Many of these things are in the environment of public transportation. And heavy equipment is rolling down our road. Trucks weighing in excess of 100,000 pounds are much different than a vehicle weighing 3,000 pounds. And I think we need to consider all these different aspects of reducing waste.
Thank you very much, Mr. Falk. Minister, I understand you need to go, and I appreciate you staying a little bit longer. Mr. McGregor still hasn't finished his round. Would the officials be able to stay?
Yes. Yeah.
Thank you. So I very much appreciate that. And we really appreciate your testimony today.
Thank you.
Thank you.
Thank you. And Mr. McGregor, I'll turn the floor over to you, and I'm sure Mr. Pentney and his colleagues will very ably answer the questions.
Thank you. I just wanted to go over the comparison between Canada and Australia. And I know, Mr. Yost, you gave testimony before the Public Safety Committee, and you said that, the state of Victoria, it's hard to compare because in the state of Victoria, they do 3 million breath tests out of a population of 6 million. And just following up on what Mr. Cooper was talking about, about setting up a police road check where everyone is checked. I have actually been through one of those in the state of Tasmania. It was a large sporting event. Everyone coming down the highway was made to blow on a device, and then the plastic tip was changed, and it was like an assembly line. Everyone was going through really quickly. Australia is a very large landmass with a small population, very easy to compare to Canada. I'm just wondering, when you look at the enforcement resources being put into 3 million breath tests out of a population of 6 million, and you look at Canada's rates of drunk driving, which have all been going down, thankfully, due to that increased awareness, more police resources. I mean, could you not make an argument that with putting more resources into selective breath testing, that we would see that downward trend go with more education, more enforcement, or perhaps mechanisms where everyone is being treated equally with breath tests and the randomness is gone, so we're not subjecting it to the whims of a police officer anymore?
Well, the state of Victoria is a relatively small state with the city of Melbourne, about 80% of the population, if not more. They have booze buses that they set up. They're regularly pulling everybody off of the major highways. More or less a situation like that might apply in Toronto or Montreal, perhaps. I don't know.
Or Vancouver.
Possibly, yes. More difficult in many other locations. But that is also the state that I was referring to, the review of random testing time, which can't be in the same place all the time. Doing those tests over and over, if people are driving around you, is not going to achieve the goal that you're seeking. So I would never argue against more enforcement. It would be wonderful if we could have more enforcement, but police have stretched resources in many ways. We're hoping they'll put more resources into drug-impaired driving, get more DREs trained, etc. But those will be issues individual police forces and their municipalities will have to decide what the resources they want to put into it.
And the reality now is that the evidence that we have is that under the current approach, a significant number of people who are impaired behind the wheel are not being detected by police. We have, as you've said, a very easily available scientific method of determining with little intrusion in a regulated environment where they're exercising a privilege, the opportunity to determine with greater certainty. And I think as Mr. Yost is indicating, our hope is that there's a whole variety of different techniques and tools used by police to try to enhance the deterrence. And some of it may be just as you experienced in Tasmania, but there will be a variety of other circumstances. And given the challenges associated with the current situation and the continuing, notwithstanding the successes, and I think in looking at drug-impaired and alcohol-impaired driving, that wider perspective is hugely important. As Ms. Morency said, the combination of education, I grew up in a generation where my parents had very different views about it than my children do, and that's a huge success for Canada. But we're looking at what would be the next step to try to improve and reduce the carnage on the road that exists now and the human toll.
And Mr. Penny, just on that point where you cited 50% of people are getting through under current methods, just for the committee's record, what is that figure based on? Do you have an actual study, and how was it conducted to find that specific number?
I would encourage you to look at the legislative background, and we're certainly happy to provide more in terms of the information. Mr. Yost can speak to it if you'd like.
The study is a footnote to one of these documents. I will get it to you. The reality is people will lie to the police as to whether they've been drinking. And on that subject of checking things, I do know that in Quebec, our person I deal with there says they do set up outside rock concerts and that. Now, they can't make everybody blow, but just the fact that they're there gets people thinking, I'm not sure I want to be one of those that they suspect of drinking or using drugs.
Yeah. So now, since we still have the officials here, I just want to make sure that we've exhausted questions. And if anybody has some short questions, I'm going to allow it. So, Mr. Nicholson, if it's okay with you, Mr. Penny, and your colleagues.
Thank you very much. And you've done extensive studies on the effect of mandatory sentencing and how that, and we all have a stake in doing what we can to reduce the carnage on the road here. And what is the result of your study on those jurisdictions that have legalized marijuana? How does that affect the carnage on the road? What have you found in your analysis of that?
The studies we've seen have all shown that there has been a higher percentage of people with marijuana in their system involved in fatal accidents. That is a problem in that we do not have causation studies, we do not have a lot of what level were they at, etc. This is presence of. It's not anywhere near as good as the studies we've had with respect to alcohol. But it is certainly a major concern, and is one of the reasons why this legislation is, we hope, will be in place before the legalization of cannabis. I believe that's the government's aim.
And Mr. Chairman, if I could take the opportunity, there's a study that's just been released by the Canadian Centre for Substance Abuse that we would highly commend to the committee. We'll be happy to provide it to you. It examines, the title is Estimating the Harms and Costs of Cannabis Attributable Collisions in the Canadian Provinces. And the top line of the report is that cannabis-related collisions right now, in terms of deaths, injuries, and property damage, are amounting to about $1 billion a year. So this is a study which has just been released. We think it's the first that we're aware of in Canada. We highly commend it to the committee.
We'll be very interested to see what happened, what's going on in the jurisdictions in the United States, for instance, that have legalized marijuana. Because on the one hand, as you say, we want to do everything we can to reduce the carnage on the road, and we'd like to know just what happens or what we can expect in this country when we legalize marijuana. Thank you very much.
Thank you very much, Mr. Nicholson. Any other questions from anybody else? Would you like to make a final statement, Mr. Yost?
It's hardly a statement. It's that the study about drinking drivers missed at sobriety checkpoints is footnote 21 on page 18 of the backgrounder. And Annex 5 of our backgrounder has about 9 studies around the world on the effectiveness of mandatory alcohol screening. So I refer those to the committee.
Thank you very much. We'll all read them very attentively. So thank you very much to all three of you for coming before the committee today. I very much appreciate it, as I know my colleagues do from all sides. And we're just going to take a short recess, and we're going to come back to an in-camera session after the room clears up.
you.